Peace, sovereign ones. Kae'z here, and this is the introduction to the debt disclosure statement packet, as well, or you can consider it the accepted for value packet, whichever you desire. All right, today I'm going to be providing the instructions on how to complete the process, the correct departments to send it to, and how to store and save your documents for the future, as well as the importance of submitting these same documents to the CFPB, okay, if necessary. Now, this here document that we are officially reviewing here is the debt disclosure statement. The reason that it is called a debt disclosure is because there are a various amount of questions that ask that are asked to verify the alleged debt. Okay. Now, at the top of this document, you would insert your registered mail number, as you can see here on the right. Okay, your registered mail, you will receive your registered mail number from the Postal Service when you go and you request to send something registered. All of your documents should be sent with a return green receipt or an electronic signature confirmation. You need to have something to verify that the document was received by the other party intended. So as you see here, by would be your living soul name, with the trademark and copyright for the fictitious straw man name. You too will be addressed to whatever the debt collector or whoever the debt collector is. And the reference, it will be referencing whatever account that it is. If you have a vehicle, um, the collateral would be the VIN number. If it's for a student loan, you will write student loan with the account number and the alleged amount. That's pretty much plain and simple. Reading into this, I'm not going to read it in its entirety, as I do want you to read and digest the information for yourself. Debt collector disclosure statement references offer of performance. This statement and the answers contained herein may be used by demandant if necessary in any court of competent jurisdiction. This is a legal notice of billing error. I dispute the validity of this debt. I accept your offer for verification, and per the Truth in Lending Act at 1 through 5 USC subsection 1601, 1667, I demand that you send verification and validation of said alleged debt. Verification is only an affidavit with an oath of deposition by a person signed under penalty of perjury. Penalty of perjury is punishable by imprisonment for 2 to 4 years in the state prison. Send verification to me with your original notarized signature on it. Do not send me copies of fraudulent monthly statements or forged applications. And then state you send me verification. Send me only true, legal, valid, signed, and notarized verification of any purported debt as defined by law in the Uniform Commercial Code and all other legal sources. If you do not respond within 10 days, to validate this alleged debt, it will be accepted as tacit consent and agreement. Okay. And then here it states that the validation of debt can either be a signed judgment order or an accounting, which is signed by and dated by the person responsible for maintaining the account general ledger. A copy of the consumer credit contract is not sufficient to validate the debt. Validation requires presentment of the account and general ledger statement signed and dated by the party responsible maintaining the account. And here are the cases that have stated this. All right. I also demand a certified copy of the original contract between the original creditor and me with both our signatures on it, including all pages, both front and back. The original will be subpoenaed at a trial, and a copy will not be admissible. I have determined that either you or the original alleged creditor have extended credit, money of an account, but are requesting that I repay you in money of exchange, and lawful money at that, which creates at least the interference of inequality of obligations on the two sides of the transaction. Money, including unlawful money, is to be exchanged for bank credit. I have also determined that either you or the alleged creditor never lent any of your own pre-existing money. Credit or assets as consideration to purchase may allege notes or credit agreements. In this event, there is an utter failure of consideration for the loan agreement. Okay. Have you purchased evidence of an alleged debt at a discount? If so, you are now using the U.S. mails in a fraudulent attempt to collect not only a charge off, uncollectible and alleged debt, but you are trying to induce me to give you more than you paid for it, which is illegal in mail fraud. I will not delay in turning you in to the postal inspector for criminal prosecution, penalties and sanctions for you and your company. All right. This debt collector statement is not a substitute for nor the equivalent of the herein above requested verification of the records, confirmation or correctness, truth, or authenticity by affidavit, oath, or disposition. Black Laws Dictionary, 6th edition, L990. Reference the alleged debt that okay, wait a minute, and must be completed in accordance with the Fair Debt Collection Practice. Applicable portions of the Truth in Lending Regulation Z, 12 CFR 22.6, and demands and cited above in offer of performance. Debt collector must make all required disclosures clearly and conspicuously in reference the following. Now, I highly recommend that you go in and look up these practices that are mentioned and to provide yourself greater clarity on what exactly you are referencing in the affidavit. So it goes into the questions and it asks, what are the full names and addresses of the social security numbers of the debt collector agents? For those of you who do not know that in order for someone to claim that you owe or to come after you for a debt, an alleged debt, you must have their full names, addresses, and social security numbers. So if you ever receive a call that says this is an attempt to collect a debt and any information retrieved will be used for that purpose, when that agent gets on the line, you get that full name, that address, and you request that social security number. If they refuse to give that social security number, you can always request as well the EIN number of the company that they are calling about. If they refuse to relinquish that information, then they have therefore violated you, and they have talked about an alleged debt that cannot be proven. Moving on, what is the name and the address of the alleged creditor or of the alleged original creditor if different from the debt collector and the original account number? Where did the money come from for this alleged debt? Give the source and provide detailed accounting entries for this and explain if money and credit was loaned. So as you can see here, we know, or if you did not know, money is a colorable fiat. It is not real. It is not backed by neither silver or gold, and it has absolutely no value. Okay. We are pushing around basically what is monopoly money. All right. Currency is completely null and void. All right. So we're basically saying, what kind of money was it that you got paid with? And where did it come from? Because if there is no money, what are you talking about? There is no debt. All right. What is the total alleged debt owed? And is it in dollars, Federal Reserve notes, or credit units? So we like, how did you get it? What is it? How did this debt get paid? What were the sources and amounts of the money used to create the alleged debt? What was the total amount of money that was risked when the alleged account was created? So I'm not going to read all of these. However, I will stop and read a few. How can the creditor, I'm reading here, how can the creditor or debt collectors' liabilities increase by the amount of the loan if they did not receive a deposit or a loan or an exchange for the alleged debt? Have any insurance claims been made by any creditor or debt collector regarding this alleged account? Have any tax write-offs been made by any creditor or debt collector regarding this alleged amount? Have any judgments been obtained by any creditor or debt collector regarding this alleged account? At the time of the alleged original agreement was executed, were all parties advised of the importance of consulting a licensed legal professional before executing the alleged contract? So they have 10 days to answer these questions, you guys. Read through this document in its entirety, gain a broader understanding, research what it is that you don't know, such as certain US codes, certain UCCs that are mentioned. And then you will send the notice to respondent. The debt collector's failure, both intentionally and otherwise, in completing and answering every question and requesting and excuse me, every question and request herein, and returning this debt collector disclosure statement, as well as providing demandant with the requisite verification validating the here and above referenced alleged debt within 10 days constitutes the debt collector's tacit agreement. The debt collector has no verifiable, lawful, bona fide claim reference the here and above referenced account, referenced the alleged account, and the debt collector tacitly agrees that the debt collector waives all claims against the demandant and indemnifies and whole depend and related regarding any and all collections beginning, and that debt collector will pay $3 million to the demandant as damages for time spent responding to the attempts per security agreement. So this security agreement is going to be the security. If you don't have a security agreement number, which is for those who have a UCC, or if you plan on getting one, when you file your UCC 1 financial statement, this here is your month, 05, the day, 30, the year you were born, and then the year that it is. Okay, that is where you will update the security agreement number. Okay. Debt collectors must timely complete and return this debt collector statement, along with the required reference documents in said debt collector disclosure statement. All right. You're going to get this document notarized. Make sure that you update the time or update the year, the month, etc. Scan this document into your computer and save it to a flash drive for future references. When you send over this document, there are a list of instructions that are provided for you. However, you would attach the primary bill, meaning the bill or the invoice or the request for payment in its entirety. It have to not it you. So if you owe $10,000, you're not going to and they send you a bill for the minimum payment of $450. That is not going to be the document that you submit. You want a document that has the full amount of the alleged debt listed. Okay. What you're going to do is you're going to place a stamp on the right corner of that document. Using a red pen, you will write your name through that stamp diagonally from the bottom of the left-hand corner to the right of the top-hand corner, okay? Once this is done, you're going to write a clause that is provided in the instructions through each page of every invoice, through each page of the bill, the invoice, whatever it is they send you, the request for payment. You're going to write this clause that is provided to you in the instructions, okay? You're going to write that on there. Write it on the whole page, like as big as you can, or to where it's legible. Make sure that it is legible. And you will do that in red ink, okay? You're going to submit this document to the alleged debt collector, okay? And you will give them time to respond. Once you submit this document, after the 10th day, you will contact the CFPB and you will put in a complaint using the, I've given you a template, okay? I've submitted the template that you need to put in your complaint on the instructions. to file your complaint. And you're basically letting them know that you have submitted a debt disclosure. They did not respond within the 10 days allotted. Therefore, this contract is null and void. The alleged debt is null and void. And you would also let them know that for your remedy, you want all debts cleared and to be shown as paid in full on your credit report. Okay. That will conclude the review of the debt disclosure statement in its entirety. We will next be reviewing the HJR 192 that will also be submitted to the debt collector as well as to the CFPB when you file your complaint. I'll see you in a minute. Peace, sovereign ones. We are moving along in the debt disclosure statement packet, the instructional phase and course. We are now reviewing the official certificate and publication pertaining to the HJR 192 Public Law 7310 as it pertains to all debts being discharged as well as all American debt being obligations of the government. Okay. What you'll see here specifically is the document that would be submitted, and you can send a copy because you will want to keep this for yourself. You will submit this document with your debt disclosure statement along with the invoice of the full amount that they would send you. Sending everything registered mail and requesting a return green receipt, which is was known as a postal form 3811, or you can get an electronic signature, whichever you prefer. And it reads, this is to certify that the collections of the Library of Congress contain a publication entitled The Statutes at Large of the United States of America, and that the attached copies of part 1, volume 112 and 113, this title page of pages 112 and 113, HJ Resolution 192, Joint Resolution to assure uniform value to the coins and currency of the United States, June 5th, 1933, are a true representation from that work, okay? So it reads, I'm not going to read this in entirety. I'm going to read the first couple paragraphs, and you can read the rest to gain a broader understanding. It is a lot of therein who are in, out, a whole lot of jargon that they could have just blatantly said what they needed to say. But of course, that, that's not going to happen. And it reads, resolved by the Senate and the House of Representatives of the United States of America in Congress assembled that every provision contained in or made with respect of any obligation which purports to give the obligee a right to require payment in gold or a particular kind of coin or currency or in an amount in money of the United States measured thereby is declared to be against the public policy. Okay. And no such provision shall be contained in or made with respect to any obligation hereafter incurred. Every obligation heretofore or hereafter incurred, whether or not any such provision is contained therein or made with respect thereto, shall be discharged upon payment, dollar for dollar, in any coin or currency which at the time of payment is legal tender for public and private debts. Any such provision contained in any law authorizing obligations to be issued by or under authority of the United States is hereby repealed. You hear repealed means no, but the repeal of any such provision shall not invalidate any other provision, or authority contained in such law. All right. I'm going to jump down here. Hold on, let me read this as a matter of fact. B, as used in this resolution, the term obligation means including every obligation of the United States expecting currency payable in money of the United States, and the term coin or currency means coin or currency of the United States, including Federal Reserve notes and circulating notes, of Federal Reserve Banks and National Banking Association. Now, let me read this here. All coins and currency of the United States, including Federal Reserve notes and circulating notes of the Reserve Bank hereto and hereafter are issued, shall be legal tender for all debts, public and private. Below are standard weight and limit of tolerance provided by law for the single piece shall be legal tender only at valuation in proportion to their actual weight. So that was basically speaking about gold coins. That's the only real money, you guys. This here publication is letting your debt collector know that there is no money, and the alleged debt that you say I owe is in fact invalid. Okay. So you submit these documents to the bill collector or the mortgage company or whoever it is that says that you have an alleged debt. Okay. I'm going to I'm going to go ahead and conclude the review of the HJR 192 certificate from the Library of Congress. And I'm going to go over here to the instructions so that I can read you this clause. And that will conclude the course for the debt disclosure or accepted for value portion of the course. Peace, everyone. Kae'z Shar here, and we are concluding the course informational phase for the HJR 192 or the debt disclosure statement packet. Okay, so what we have here is basically the rules of how to complete the process, what I basically walked you through. I just wanted to stop here and read you the clause that would be written over each page of the document that is claiming that has the full amount of the alleged debt. Okay. Accepted for value and consideration, UCC subsection 3-401. This item is returned to you for returned to you for full discharge, settlement, and closure of the accounting. All endorsements front and back are accepted for value and consideration, UCC subsection 3-419, and exempt from levy under federal rules of the civil procedures rule accordance with the House Joint Resolution HJR 192 7310 Title 118D Part 2 USC 1-103 UCC 1-202 UCC 3-305 UCC 9-607 UCC 9-609. Adjust the accounting and release the products, fixtures, and proceeds herein. For right here, the value is the full amount of whatever they are saying that the alleged debt is. By is going to be your autograph. Okay. And this is what you will write over the document in red ink, over the invoice or whatever it may be. Please ensure that you scan all the documents in the system once again, as well as make sure that you submit your claim to the CFPB. And that will conclude the review of the instructions for the debt disclosure statement, aka accepted for value packet. I thank you guys so much for your support. If you have any additional questions, feel free to email info@transitiontofreedom.org. And I thank you guys so much. Be blessed and have a wonderful day.